pledge to Nigeria and my country to be faithful, loyal, and honest, to serve Nigeria with all my strength, to defend her unity, and uphold her honor and glory. So help me God. Thank you so much. If you may all please be seated. My Lord, Honourable Justice B.B. Kanyip, President of the National Industrial Court and our keynote speaker for today. My Lords, Judges of the National Industrial Court here present, Honourable Justice Obaka, Honourable Justice Orji, Honourable Justice Weneka, and Honourable Justice Damachi, Trustees of the Employment and Labour Lawyers Association, Leonard Silks here present. I see Mr. Uwa, Senior Advocate of Nigeria, and Mr. Kuti, Senior Advocate of Nigeria. To our panelists, moderators, distinguished speakers, to our sponsors, colleagues, ladies and gentlemen, good morning. We can do better. Good morning. Do me a quick favor. If you can look to the person to your right and to your left and just say good morning and welcome. Great. My name is Vincent Iweze, and I have the honor of serving as your compere for today's event. As such, it's my distinct pleasure to welcome everyone to the 2025 Annual Conference of the Employment and Labour Lawyers Association of Nigeria, and is aptly themed Employment Law at Crossroads, reflecting on the past decade of decent work advocacy, charting the next. It's also 10 years of ELLAN, so a round of applause for ELLAN as they also celebrate 10 years. Now, it's your first time attending an ELLAN event. Let me tell you, welcome. ELLAN was conceived in 2015 as Nigeria's premier association of employment and labor lawyers, with a vision of becoming the largest and most respected network of professionals and top-tier firms. ELLAN has the mission as the preferred resource for point of stakeholders seeking insight on labor and employment matters in Nigeria. Now, if you've had a chance to go through the program, you will realize that we have a power-packed house today. We have the most respected voices in employment and labor law from the bar, the bench, and the boardroom in this room today. And the agenda has been carefully curated to ensure that it fosters dialogue, critical thoughts, and I encourage everyone to be part of that today. Now, for my learned colleagues, in addition to the wisdom you'll get today, I'm happy to announce that this is an NBA ICLE event. So you're also adding to your points. As we all know, we need 5 points to ensure we get our seals next year. Now, we're going to begin today with a keynote address, going to a fireside chat, and we have a lot of panel sessions that were very, very insightful. I encourage everyone to listen attentively, to partake in the conversations, and please feel free to ask questions, as we hope that today will be very, very engaging. I would also like to thank our sponsors, our gold sponsors, silver sponsors, and bronze sponsors who have made this possible today, and to all our attendees who have taken time from their busy schedule to be with us today. So without further ado, please join me in welcoming our first speaker, the chairperson of the Conference Planning Committee and a partner at Stream Sowers and Cone, Mrs. Omono Blessing Omagohi, as she gives her opening remarks. So a round of applause for her, please.
Good morning, my noble lords, senior advocates of Nigeria here present, my senior learned colleagues, and distinguished ladies and gentlemen. Standing on the already established protocol, it is with great joy and gratitude that I welcome you all to this historic conference, the maiden conference of the Employment and Labour Lawyers Association of Nigeria, ELLAN. With the theme, Employment Law at Crossroads, reflecting on past decade, decent work advocacy, charting the next. ELLAN was conceived in 2015 in a small meeting room by Jamiu Akolade, then an associate at a commercial law firm in Lagos, Nigeria. His idea was to create a forum where practitioners in the labor and employment space can discuss issues that affect practitioners in the practice area. Today, this small meeting of employment and labor law practitioners, it's 10 years old, an association with members from all parts of Nigeria. ELLAN has grown significantly with the creation of 3 committees: Event Committee, Public Advocacy Committee, and Publication Committee. All these committees are targeted at addressing pressing issues of labor and employment, access to knowledge, and access to justice. We are particularly happy today that the 10th anniversary of ELLAN coincides with the maiden conference as well as the launch of the maiden ELLAN journal. One significant achievement of ELLAN, which I consider as a 10th anniversary gift, is the launch of the journals, just by my left-hand side here. An important contribution to the growing body of scholarly literature on labor law and employment. I encourage everyone to please grab a copy before they leave this conference. The conference has been accredited by the MBA Institute of Continuing Legal Education, MBA ICLE, for the CLE unit. Accordingly, all legal practitioners who are here today and those that have joined virtually will receive a certificate of attendance reflecting their credit hours earned. The theme of this conference was deliberately chosen to stimulate informed discussions on the evolution of employment and industrial relations in Nigeria over the past decades. Key to the conversation are contemporary issues such as workplace, diversity, innovation, and far-reaching implications of the third alteration of the 1999 Constitution of the Federal Republic of Nigeria. This amendment, particularly Section 254C, 1A to K, and subsection 2 through 6, grants the National Industrial Court of Nigeria, the NICN, exclusive jurisdiction over matters relating to labor, trade unions, industrial relations, and employment disputes. Notably, the amendment also empowers the NICN to apply international best practice in the adjudication and resolution of labor disputes, hereby aligning Nigerian labor justice system with globally recognized standards. The conference will also employ practical application of these best practices within the workplace, highlighting the importance of proactive internal mechanism for conflict management, effective dispute resolution strategies, and international policy that promote industrial harmony. As we reflect on the past developments and assess the impact of these constitutional reforms, we must also look ahead towards strengthening our legal and institutional framework to better serve the dynamic needs of the Nigerian workforce. I encourage all participants to prepare for a thought-provoking and impactful conference. We have assembled a team of distinguished speakers and subject matter experts who will offer rich insights into the various sub-themes developed from the conference topic. Their contributions will be invaluable as we seek a way forward in evolving landscape of employment and industrial relations. I want to use this opportunity to specifically thank my Lord, Honourable Justice Benedict Kanyip, the President of the NICN, who has constantly supported ELLAN and has deemed it fit to honor our invitation with his presence here today. My Lord Justice Kanyip, I say thank you very much, my Lord. I also thank all my noble lords here present for making out time to attend this conference. Thank you, my lords. I joyfully say thank you to all the sponsors for supporting us financially to achieve this success. To achieve the success of this conference, we are all very grateful to our sponsors. I want to also use this opportunity to thank participants and delegates here present and those who have joined us virtually. Thank you for trusting us and registering for this conference. I assure you that your experience at this conference will be exceptional as you will have value for your registration, value for your time, and there will be great opportunity to learn from experts in the employment and labor law field and a robust networking opportunity. To delegates who have joined us from outside Nigeria, other parts of Africa, thank you for coming. They are here. Thank you for coming. I say thank you for coming all the way to discuss with us here in Nigeria. We are very, very, very grateful. To members of the planning committee, thank you for your time. You had sleepless nights to ensure that we have a successful and exceptional conference. Thank you for your commitment, dedication, and time. May the Almighty reward you for all your hard work. I am very, very grateful. Special thanks to Precious and Tommy, in charge of the Secretariat, who has worked day and night to ensure that members of the Conference Planning Committee all had the information they needed to support this conference. Thank you very much. I remain entirely grateful to Stream Swans and Cone for creating an enabling environment for me to perform my role as chairperson effortlessly. Thank you, Mr. Waitigwe SAN, one of our senior partners here present. I am grateful. I was always out of the office and they did not complain. They gave me time to ensure that I organized this conference with the Conference Planning Committee. Thank you, sir. Many thanks to my husband, Anthony Tosa Magomi, who has encouraged me to accept this role as the chairperson of this conference and constantly assured me that the conference will be a huge success and an exceptional one. Thank you, honey. It's not here, but, oh, it's here now. Thank you. We don't sleep at night. We keep planning, making calls, so thank you. So after this, I will have the time to spend with you. Finally, I give thanks and gratitude to the Almighty for making it possible for this conference to be held amidst all the challenges. 9th July 2025 was a dream for many months, and today it's a reality. Happy birthday, ELLAN. Please, I encourage all delegates to use this opportunity to connect, build relationship with experts and practitioners in the employment and labor law community in Nigeria and beyond. Move around, chat, discuss with other delegates to build your network. Once again, welcome to the 2025 Employment Law Conference organized by ELLAN. Thank you, everyone.
Please, another round of applause for Mrs. Amagomi for the lovely opening remarks. As it said, the journey of 1,000 miles starts with a single step. And our sincere thanks to ELLAN for not just conceiving the idea, but ensuring that there was adequate follow-through. Now, at this juncture, I have the singular honor of introducing our keynote speaker. He's a renowned jurist, academic, and reform advocate. He holds LLB, LLM, and PG degrees from the Ahmadu Bello University, Zaria, and was called to the Nigerian bar in 1986. He began his career in legal research, serving at ABU and later associate research professor at the Nigerian Institute of Advanced Legal Studies. He joined the National Industrial Court in the year 2000 and became its president in 2019. Like they say sometimes, it takes 19 years to become an overnight success. Over the years, he has contributed immensely to labor law reform, judiciary development, and consumer protection nationally and regionally. My Lord has participated in various law reform initiatives, including the drafting of key labor legislation and policy for Nigeria and ECOWAS. Internationally, he serves on the ILO Committee of Experts on the application of conventions and recommendations. He's the author of several legal texts and recipient of numerous accolades. And also to add, he has expanded our jurisprudence by many thought-provoking decisions. He's an officer of the Order of the Federal Republic of Nigeria. He's a fellow of the Nigerian Institute of Advanced Legal Studies and has the Bar Presidential Award by the Nigerian Bar Association. He's a fellow of the Chartered Institute of Taxation and the Chartered Institute of Arbitrators. He's married and blessed with children. A resounding applause for my Lord, Honourable Justice Kanyip, the President of the National Industrial Court, as he comes to the podium. Thank you so much, my Lord, for making our time to be with us today.
Thank you, MC. Sometimes when people talk about you, you wonder whether you are the one they're referring to. My lords, senior advocates of Nigeria who are here, members of the outer bar, all industrial relations practitioners who are here and who may not be lawyers, don't worry. I always remember that when it comes to industrial relations and the law, keep out the law. Distinguished ladies and gentlemen, let me also thank Madam Sharon. I'm sure they don't know you're here. I only told her of this event yesterday, and today she has come with her TVC crew. Thanks for honoring the invitation and welcome. Congratulations, ELLAN, on clocking 10 years of your existence. You've succeeded where we have not succeeded. You have an association of employment and labor lawyers. Since the time of my predecessor, we've been trying to form an association, some kind of conference of labor court judges across Africa and the English-speaking Caribbean. We've not succeeded. The closest we got to doing it was during the time of Justice Kutigia's CJN. And we wanted permission to have it, but he said we must go through the National Judicial Institute because that's the body that is legally responsible for judicial education. We never got to doing that, and so till today we've not formed it. But we are still in talks. So congratulations for achieving something that we couldn't achieve, or we are still hoping we will achieve at the level of judges and judicial officers. The chairman of the planning committee was actually on my neck, not once, not twice, to ensure I'm here today. My first impression was to tell her, look, I will ask one of my colleagues to do it. And they insisted, no, they wanted me to come. So I cross-checked my itinerary and luckily discovered that today I could be free. And that's how I'm here today. So I'm not sure I've met your husband before, but I understand he's here. If the way she disturbed me is how she disturbs you, I think I have to doff my hat for you. Anyway, we are here today. I sent an advance copy of the paper to her, and she asked whether she should distribute it before today or I wait until after today. I told her, do whatever you want. So I don't know whether she did or not. But the point is this. As at yesterday, I have even added some things inside. So that has always been my problem. Anytime I write something and I go back to it, there's always something to add. So if you have a copy of this, better wait for the updated version. As we go along, we'll point out what are the additions, as you would see. Secondly, it's a bit bulky. And again, I went back to the chair of the organizing committee and was like, based on what I saw in your programs, you have a loaded period, agenda. Do you think you'll be able to cope? She said, we will manage. Anyway, thank God I'm the first speaker. So you will have to be patient with me until when I get tired of talking, then you can take over with the others. Now, labor lawyers have been called, and I quote a writer, to remain alive to the historically contingent nature of labor law and be prepared to revise our present understanding of the field by reference to its historical legacy. I deliberately started the lecture that way, just so that we can understand that the issues we are addressing are issues that cut across academics and practical things in the field. When I say academics, I'm more interested in matters of concept, matters of ideology, not just about how they apply in practice, but about how they can even be justified in the first place. Because until we do that, we may not even be able to appreciate the theme, employment law at Crossroads. Now, why this call? Because labor law has been in crisis for a while now. Today's topic centers of employment law being at Crossroads. While I'm entitled to assume that we all know what Crossroads means, I actually gave the dictionary definition, which says it is an intersection of two or more roads, a point at which a crucial decision must be made that will have far-reaching consequences. So in the context of employment law being at Crossroads, it must be understood as the clash between traditional protections versus modern employment trends, for which crucial decisions with far-reaching consequences must be made. But why the choice of employment law, not labor law? If you look at your theme, you would see employment law at Crossroads. I'm asking, why not labor law at Crossroads? Is there any difference between the two, so that employment law being at Crossroads is necessarily different from labor law being at Crossroads? When I first saw the topic, of course, I didn't see the word labor. So I originally thought maybe because your name starts with Employment Lawyers Association, that was the reason. Then after a second look, I saw there was also labor. So my first thought was that the organizers of today's conference, the Employment and Labor Lawyers Association of Nigeria, merely chose employment law because the word employment prefaced their name. But then labor too can be found in their name. So why not employment and labor law being at Crossroads? Would this be tautologous? Basically, the question remains whether there is any difference between employment law and labor law as to make any consideration of the law being at Crossroads one that must involve values that differ between the two. In other words, does the difference between employment and labor also go to it being at Crossroads? In Nigeria, we often use the two terms interchangeably. We talk of labor law even when we mean employment law. I don't know whether my colleague, Justice Professor Oji, when she was teaching labor law, hinted on some of these issues. If you think this is easy enough, then wait for Harry Otters, who, in answering the question, who is labor law for, prefaced the answer thus, and I quote, labor law is about labor, which operates in the context of employment and which is designed to protect workers. He continued that if employment law is invested with social and economic significance, i.e. providing workers with not only the means of financial support and contributory role in society, but also with a sense of identity, self-worth, and emotional well-being, then surely the continued importance of labor law ought to be assured. Now, can we see the oscillation between the words labor and employment? An author, Manfred Weiss, in taking up the notion of labor law, explains that in jurisdictions like the United States of America, it is understood as referable to only collective labor relations, while in continental Europe, it is taken for granted that it covers both individual as well as collective labor law. And then I quoted him, but let me just skip the quotation. So, there is no gainsaying that the general structure of labor law itself is today being questioned. I hope you are following the trend. The structure itself is being questioned. So when you worry about it being at crossroads, I want you to understand it that from an ideological or conceptual point of view, there are question marks even on the limits or the scope of the subject matter itself. There is thus disagreement as to the boundaries of labor law, and hence what is labor law itself. A commentator, for instance, talks of the identity crisis of labor law and gives the example of France, where manuals have abandoned the traditional title labor law in preference for the law of employment. In order to underline that the epicenter had moved from labor relations inside the firm or organizations to labor market generally, with its new problems of market access, job creation, sharing of labor time, employability, and connections between working conditions and social citizenship. In other words, the orthodox labor law had restricted itself to just the relationship within an organization. You will later find out that historically, labor law concerned itself with just the unit, the organization, the factory. But today, when we talk about labor law, in talking about labor market issues, we have recognized that issues of labor law are no longer restricted to just units or to industries or to organizations. We begin to talk about its impact even within the wider sphere. In fact, there are authors who believe today that you cannot but consider labor even when you're designing national development policies. In this sense, the problem becomes self-evident in that labor, with which labor law has until now been concerned, seems to be found less and less, and where it is found exhibits characteristics not readily reconciled with the traditional model. And so I make the point, again, we are going to talk more detailed, if time permits, about this. If you look at section 254C1 of the Constitution, which donates the chair of the planning committee in her address, alluded to it, donated jurisdiction to NIC, deliberately uses the word labor and employment, and then preface them with the word any. So it tells you the scope. If you want to take labor as distinct from employment, the Constitution wants to tell you, we note that difference, but we are donating jurisdiction even in respect of those differences to this particular court. Much later, towards the end, I will tell you how that was used in respect of even defining the scope of jurisdictions of the NICN. Another author couched the challenges of labor law in terms of conceptions of the notion of worker. The melting boundary between employment and unemployment, with job insecurity elevated into a market asset, the threat posed by globalization in undercutting basic social needs, yielding to the necessity to counterbalance the hegemony of free trade ideology and growing inability of trade unions to cater for those out of work or even marginal workers. Later on, I'm going to make the point that even when you're discussing rights of workers, you must note that they come in three stages. You have pre-employment rights. In other words, even applicants for jobs have rights. If you make it deliberately clear to an applicant that he's because he's not of a particular make or place or whatever, in other words, If you discriminate against him and he can prove it, he can have a case in NIC against you. And if you look at the ILO standards, there are conventions that have been made specifically tailored towards protecting applicants for jobs. In other words, the labor standards that ILO gives us are labor standards that are applicable not just to those in work, but even those who are out of work. And there are two categories of people who are usually out of work: applicants who are looking for work, or retirees who have resigned or retired from work. So, labor rights inure at 3 levels: pre-employment, while in employment, and after employment. And all of this, in terms of the rights that come, if you look at the context in which jurisdiction is donated to NIC, you would find out that at each of these 3 stages, once you have complaint, you can come. I have seen cases, in fact, Court of Appeal, although in respect of a vicarious liability issue, had even said, unless there is an employment relationship, NIC does not have jurisdiction. And for me, it was a misinterpretation of the rights of an employee within the context of the scope of jurisdiction of the NICN. When the NIC section 254C1 of the Constitution talks about any labor, any employment, and all that stuff, and ends up with and matters incidental or connected therewith, you cannot but, as Justice Obuanya held in one of the cases, he decided that even issues on employment policy must come to the NICN in terms of adjudication. Now, all of this point to the importance of ensuring that labor law is facilitative of collective bargaining and social dialogue rather than simply providing for individual rights. We will later talk about the relative advantage or difference between individualizing rights and collectivizing those rights. When therefore Section 2541 C1 of the Constitution donated to the NICN the power and jurisdiction to apply international best practices or standards, the court has been properly placed to solve the disputes that would arise in the world of work, even if it is on a case-by-case basis. Now, what's my reading of the situation? First, the talk of the law being at crossroads must start with the terminological difference between employment law and labor law. 2, labor law is referable more to collective labor relations, while employment law is referable more to individual rights of the worker and employee, which thirdly raise the problem of the individuation of labor rights, especially the extravagant individualism of the common law. Whether this is preferable to the collectivization of workers' rights. What labor law would ordinarily be about remains a contending issue in any labor employment law discourse. And this yields to the 4th point. Employers generally prefer, and they do work for, the individuation of labor rights, of workers' rights. They prefer to stand against an individual, worker or employer or employee, rather than against the collective power of workers or employees as represented by trade union power. All this naturally cumulates to compound the issues and to make not just employment law but also labor law to be at crossroads. Even within the context of employment law, strictly speaking, it is often with great difficulty that employers agree with workers over issues of wages and hours of work, discrimination in the workplace, wrongful termination, typified by the tension between flexibility and security, leave, whether paid or unpaid, workplace safety, and given the intrusion of digitalization and artificial intelligence into the workplace, we have problems relating to privacy rights in the workplace. And here we talk about the worker's right to be let alone in relation to what employers contend, that they must have a right not to leave the worker alone. Historically, it was the collectivization of employees in terms of collective self-regulation and legislative intervention that characterized labor law. And the main goal was to compensate for the inequality of bargaining power that existed between workers and employers. Aside this, Manfred Weiss identified 4 goals attributable to Hugo Schinsma, the foremost founder of German labor law, as the driving force for labor law regulation. First, the object of transaction in an employment relationship is not a commodity, but the human being. When we say, I think starting with Pope Leo XIII, who in 1891 in his encyclical on capital and labor, in Latin termed Rerum Novarum, in other words, addressing the issue of rights and duties of capital and labor, he was the one who first admonished that labor is not a commodity. And the ILO sees on this, and it is now, in fact, the very first fundamental principle of the rights at work. Labor is not a commodity. Now, the whole idea about labor not being a commodity is that when we agree to work, it is not the human being that goes to it. Otherwise, it would be slavery. It is your skill, what you have to give, that is the item of transaction, not you as the human being. Of course, like I point out, we employed workers, but what we got, we are human beings. It's a common refrain in the world of work. And the whole idea being that the fact that you came to work and you're giving your time, your skill, does not make you less human. It allows you to go with yourself in terms of your dignity, your pride, and all that goes with it. But more importantly, it allows you, even in the workplace, to claim whatever is entitled to you as fundamental rights that accrue to you as a human being. Second, personal dependency is a basic problem of labor law. The concept of personal dependency, with its emphasis on control, if you look at traditional labor law, particularly if you read cases like Shino Securities and Afropac, the Supreme Court was very specific that one of the basic yardsticks for determining whether there is a contract of service or not is control. In other words, to what extent does the employer control you in terms of what you do? So that is personal dependency, because you have to be controlled by the employer before traditional labor law recognizes you as an employee or a worker. So personal dependency is a core issue in labor law. It is what is used to differentiate employees from independent contractors. And it is a key factor in determining whether an individual is entitled to employment protection rules / regulations. This dependency relationship is accordingly a hallmark of an employment relationship, which triggers the application of labor law. Later on, we are going to see how utilizing some of these traditional concepts in applying them to modern day work relationships give us the difficulty in understanding whether there is even an employment relationship or not. Third, since human dignity may be endangered by the employment relationship, labor law must safeguard human dignity. This goal of human dignity is captured by the ILO in its decent work agenda. Because these three goals are closely related, they explain why employment contract is not just a contract amongst others. In other words, it differentiates this type of contract with other kinds of contracts. It establishes a relationship sui generis. Fourth, labor law is not merely for the employment relationship. And this is where, incidentally, some of us are mistaken. And when I say some of us, including even appellate judges, when they say because there is no employment relationship, NIC, you can't even look at this issue. It's like restricting the scope of labor law itself. So, labor law is not merely for the employment relationship. It has to cover all needs and risks which have to be met in an employee's life, including the law on creation of job opportunities, as well as post-employment rights and benefits. The application of labor law goes beyond those who are working, i.e. in subsisting employment. It encompasses those who are out of work, either searching for work, applicants, or have left work, retirees. And for instance, I pointed out some ILO conventions that deal with both those who are out of work in terms of searching for work or who have retired. And of course, I also gave a Court of Appeal decision that has acknowledged that these rights, like I pointed out earlier, are applicable at 3 levels. A fifth goal may be added, though not necessarily a universal feature, and that is the active involvement of employees in management decision making. We talk about workplace democracy, right? And then consultation, the whole concept of social dialogue, which the ILO pushes, is a concept that allows workers to have a voice at the workplace. This entrenches democracy even in the workplace. And the minimum here is often the requirement of consultation before major decisions, such as in relation to retrenchment, are taken by an employer. I'm sure all of us are familiar with Section 20 of the Labor Act. The whole concept behind Section 20 is the necessity for employers to consult employees in the event of retrenchment. So, summarily, therefore, the broad values that labor laws are designed to promote include human dignity, individual autonomy, equality, democracy, voice, etc. Accordingly, minimum wage laws are justified as tools for redistribution needed to protect human dignity. Collective bargaining laws promote workplace democracy, redistribution and efficiency, and just cause dismissals. Convention 158 of the ILO, which Nigeria is yet to ratify, talks about you cannot dismiss except on good cause. So just cause dismissal laws are needed to prevent unnecessary injuries to the social, psychological well-being of workers who depend on a particular relationship for such purposes, and to ensure a fair price in terms of security in return for workers' submission to a democratically deficient regime. When there was this research the ILO did in 2012, as between countries that have just cause dismissals as the rule. In other words, you can't dismiss without just cause. And countries that do not have, like Nigeria, where you can hire and fire at will by the common law rules. And they discovered that countries that had just cause dismissal as the rule were more developed than countries that do not have. What point am I trying to make? There is a relationship in terms of security of employment, job security, with the state of development of any country. If you have a large workforce that is not working, you have more problems than having a large workforce of people who are actually working. So, whether we like it or not, the fact of work, apart from what you get as an individual out of it, says a good deal about the state of development of that country. And in fact, the kind of security issues we face today are traceable to the large amount of unemployed people that we have around. But wherein lies the crisis of labor law? As good Davidoff asked. He answered by asserting that the goals of labor law have not changed. Free market does not produce acceptable practices in the labor context any more than it used to. To him, the crisis is not with the goals, but with the mismatch between some labor laws, statutory and case law, and the goals created by changing realities. So, a necessary point here is that historically, labor law took roots in the domestic labor market, typified by the settings of the factory, the manufacturing industry, with a relatively homogeneous workforce. Globalization was hence, at that time, not an issue. This is not so much the case today. In today's post-industrial era, outsourcing, networking, subcontracting, teleworking are dislocating strategies, changing workplace organizations. And they do it dramatically, with the workforce being no longer homogeneous. I like to tell people, you only need to think how an aeroplane is manufactured for you to know the magnitude of the issue. The different parts of an aircraft are manufactured at different countries. And these different countries often have different labor standards. By the time you cumulate this figure, you are talking of thousands, if not millions, of workers, all geared towards producing one product, and for which a distortion can affect the whole scheme. And the level at which some of these jobs are outsourced is such that you can have multiple layers or levels of outsourcing. You outsource a job to me, I can outsource part of it to another, that person can outsource part of it, until it gets to a point where whoever at the last rung of the ladder, whatever it does can affect what the ultimate outcome is. These are the realities of today's workplace. And we have to be conscious that because all of this happens in different climes, where the labor standards are different, there's no way you are not going to have problems. So, the reality of work has thus changed. New forms of work are springing out. Part-time work, fixed-term contracts, temporary agency workers, economically dependent self-employed are now in the increase. The labor market is no longer male-dominated. We have what is called the feminization of the labor market, which is now an issue. And in fact, a writer has attributed that the impact of women coming into the labor market, what he called the development of the washing machine. Because to him, the moment the washing machine was manufactured, it relieved women of a great deal of domestic work and allowed them to go into the formal sector. And that in itself has impacted on the economy more than the internet had done. So, issues of feminization of the labor market is now an issue. yielding to issues of the balance of work and family obligations, what we call the work-life balance. And then globalization putting pressure on national economies, given the relocation of production to other countries with new technologies, facilitating the division of production processes and provision of services between different countries across the globe. Later on, I'm going to make the point that capital has a way of chasing economies that have lower standards, labor standards. When I say capital, I mean those who control capital. And very often, they are employers. As emerging trends and challenges, new forms of work yield to the gig economy, raising questions about worker classification, benefits, and protections. Technological advancements, making automation and AI displace certain jobs, requiring workers to adapt to new technologies and potentially leading to new employment law issues, and globalization and remote work, where employers with global workforces or remote workers navigate complex employment laws across different jurisdictions. Despite all these dislocations in the workplace, Manfred Weiss maintains that there is no need to question the need for labor law. And this remains so even when another author points out that the belief that labor law necessarily promotes fairer outcomes may be misguided, given that labor law rules tend to benefit those in stable employment at the expense of the unemployed and the excluded who cannot find work. Now, our membership of the International Labour Organization can no longer be conceived as a national or domestic phenomenon alone, because we're a member of the international community. It was His Lordship Shirajo JCA who said the third alteration is a game changer. And he called on stakeholders in labor and industrial relations to strive in order to conform with the international best practices as obtainable in the field. Employers have been advised by Honourable Justice Ogu Umiju to be mindful of international best practices in their dealings. There is also the acknowledgement that the policy of the legislature to introduce new labor relations principles and international best practices into the adjudication of the law in employment and labor relations, though a fluid policy, points the judex to the new road to follow. So while implementing best practices such as clear policies and procedures can help prevent employment law disputes, a commentator, however, cautions that the association of best practice with the institution of those countries which have historically had higher living standards than others, or which at a given time are experiencing more rapid economic growth, may turn out to be mistaken. In other words, and I ask the question, whether or can best practices of developed countries or economies necessarily work or be good or advantageous to less developed countries? I leave you with that as a poser. The ILO in the main develops international standards, which by the Constitution is now part of our corpus, particularly those ones ratified by Nigeria. But there are 4 problems identified with standards setting by the ILO. 1, many of these conventions have actually not been ratified even by the member countries. You can imagine a country like US, which is the country often touted as the best, if not one of the best, if not the best example of democracies, is yet to ratify Convention 87. Convention 87 deals with freedom of association. So you can see that a country that preaches democracy to the world has not ratified as critical a convention as Convention 87. 2, a significant number of ILO member states are hesitant to ratify conventions. 3, ratification itself does not imply implementation. In fact, and the enforcement stroke sanctioning mechanism is still based on the idea of name and shame. The whole idea about the committee of experts on the application of conventions and recommendations is for us to monitor application by countries. And what we have seen over the years is that majority of the countries, even when they ratify a convention, don't even apply it. 4th, ILO standards are shaped more according to the needs and conditions of highly industrialized countries and not according to the situation of developing economies. When I was being interviewed for the committee of experts by the ILO, they asked me, what am I going to bring to the table if they give me the job? And I was like, all through my research life, I have been studying the law's application to economically disadvantaged groups. That's what led me into doing my PhD in consumer protection. And one of the things I discovered, in fact, that ran through the whole thesis of my PhD, that there was a judicial subsidization of even the liability rules in favor of the stronger persons with bargaining power. Rules like the foolproof production rule in tort, which says if a manufacturer by oral evidence shows that he has a foolproof production process, it is up to the consumer to disprove it if he wants to succeed against. And if you read through the cases, what do you get? Manufacturers will call a plant manager who has nothing to do with the production process to come and say, we have a foolproof production process. Then you, as a low-level consumer who does not have the resources to challenge all of this because they will not in the first place even allow you access to the factory or the production process, is now left hanging. And we have so many of our cases. The opportunity we had for the Supreme Court to rule on this was lost in Ekwe Jimino and I think Nigerian Bottling Company or so. So, all through my reading, the only exception I found was the institution of bailment, which unfortunately we are not even taught in school. The only way we knew about bailment was when you are doing contract. What was the difference between bailment and contract? What was the difference between bailment and tort? What was the difference between bailment and agency? Beyond that, we don't even know that bailment comes in 6 categories. Now, that's the only place where negligence is assumed. If you give your car for safekeeping, that's a bailment relationship. If the car gets missing, it is the responsibility of the person you gave it to explain how it got missing. It's not for you to prove negligence. So in all heads of liability, I discovered it was only bailment that was pro-consumer. So I now told them, I have done my studies at individual levels to show or see how the law treats disadvantaged people. And I discovered disproportionately that it favors the stronger bargaining people. If you look at your Sale of Goods Act, for instance, Sale of Goods Act is just a codification of the custom and practices of mercantile people. It's never meant for the buyer. And that's why the measure of damages in sale of goods, for instance, says it has to be measured. The judge has to measure it on the basis of the profit you would have made. Profitability is a business issue. It's not an individual person's issue. If I buy a car for personal use and it goes bad, and you are giving me damages by reference to what I would get if I had sold it, I didn't buy it for sale or for resale. So you can't be measuring damages in that regard in terms of what I want. The things that interest me in that transaction are three: refund my money, repair the vehicle, or replace it. What I call the R remedies, none of which is reflected in the sale of goods. So I told ILO, all through this, I have found the law disproportionately against the downtrodden. But if I come to ILO, I'm more interested in seeing whether your own standards reflect this reality. In other words, whether they are pro-developed countries relative to developing countries or not. And the lady, the director who was interviewing me, said she never for once thought about it. So I was given the job. I'm now a member. And in one of our sessions, I discovered that in their application of standards, poor countries were complaining, we don't have the resources to implement these standards. And so I raised the question, why are we not considering the issue of the state of resources needed to implement these standards? And they said that shouldn't be our concern, because these countries were part of the standard setting process. And I asked the question, when you were doing this standard setting, do you think these countries had a voice? What point am I trying to make? The very fact that standard setting, even at the level of the ILO, does not take account of the relative disparity of resources between well-to-do countries and not well-to-do countries, will impact itself on the implementation of those standards. If you compel me to sign and ratify, I simply keep it aside and do what I want. And if you look at it, Nigeria virtually every year gets a query for not applying even the standards that they ratified. One of the reasons for which NIC was given jurisdiction over ratified conventions was to do a shortcut answer to ILO by Nigeria each time it is queried. So Nigeria now can afford to go to ILO and say, well, don't blame us. They have an avenue to go and implement infractions of the conventions. If they don't seize it, that's their business. Don't disturb us. We already made it constitutional. We've given them a court to apply the standards. So if you have an issue and you don't want to go to the court, don't blame us. They did it as a shortcut measure. Now, developing economies suffer yet another setback. Traditional labor law does not capture all the issues confronting workers in developing countries, where unemployment, the consequence of which is social exclusion, and employment in the informal sector, leave workers outside the scope of labor law. For Nigeria, an ILO brief disclosed that self-employment predominates our labor market, with nearly 9 in 10 employed Nigerians, that's 87.3%, engaged in this type of jobs. In other words, 83.7% of Nigerians are outside the labor law protection, while only 12.7% hold wage-paying positions in the third quarter of 2023. The disparity is even more pronounced for women, with 90% of working women in self-employment. Remember the distinction between contracts of service, contract for service. Once you are in a contract for service situation, it means all the employment protection laws can't apply to you, compared to 84.2% of men. And for the informal economy, informal employment is overwhelmingly dominant in Nigeria, encompassing 92.3% of total employment. In other words, majority of working Nigerians are in the informal sector. This rate is even higher amongst women, with 96% engaged in informal jobs compared to 88.7% of men. As should be noted, thank you. You see why they want me to keep talking. As should be noted then, this large group of non-wage earning jobs almost invariably come outside of the protection of labor/employment. Each time we talk, just keep remembering the theme, employment law at crossroads. So when you have these large disproportionate workers who are outside the protection of employment law, then you know that there is a problem. Concerns of workers would thus depend on the pressing matters of the time as dictated by the local economic, political, and social context. We all were witnesses of COVID, right? And we know how that impacted. There are still some cases, I'm sure, at NIC where issues relating to COVID are still being litigated. So, by a 2024 assessment by ILO, while jobs in Nigeria are plentiful, decent jobs are few. All of this point to the fact that labor lawyers and labor law face an identity crisis today, with the boundaries of labor law being reformulated. As an author puts it, 3 questions depict the dimensions of the identity crisis of labor law. And he poses them as questions. 1, has the real world changed so much as to leave traditional labor law inoperable? 2, are our basic concepts of employee, employer, employment relationship, etc. still viable and hence capable of shaping our thinking? 3, are the moral ideas which motivate our enterprise still salient and capable of enabling us defend labor law? Questions as to whether we even need labor law today are now being asked. As labor laws are becoming outdated and many no longer cover workers, frequent changes in employment policy practices unforeseen by the legislature are now designed to evade the law, and interpretation of existing laws is now more problematic in the face of the changing world of work and practices. And this remains so, despite the rule that ambiguity must be resolved in favor of the employee. While the employment relationship itself may be consensual, remember, labor law applies to the parties, that's the employer and the employee, not by self-declaration or contractual stipulation. So the legal status of the employment relationship is often not one of choice. The ILO, for instance, preaches that base courts should adopt the principle of what they call the primacy of facts, not what the parties call the relationship. Look at the facts. If the relationship depicts an employment relationship, go ahead and hold it to be so. If the facts show that it is not, then go ahead and say so. The fact that the parties called it one is immaterial. That's what ILO preaches. Because labor/employment law applies to the bilateral employment relations of employee and employer, problems which typify the crisis of labor law are manifested in several ways. In consequence, employment law is indeed at crossroads, facing numerous challenges and complexities in today's rapidly changing work environment. Here are some key issues and areas of focus. 1, you are an employee only if you have the characteristics of an orthodox traditional employee. 2, an employer can evade labor laws by simply altering the characteristics that should trigger the application of labor laws without changing the true nature of the relationship. 3, An employer can evade labor laws by sham appearances, as where in 0 hours work contracts work is made contingent on interest of both parties. You have a contract with an employer, but you only work when he wants you to work. And then he makes it look like you two also have the right to say, I will work only when I want to work. Here, judges must remember that the employer has an interest in misrepresenting the relationship between him and the employee. 4, it is not uncommon to find workers in same establishment doing the same work but treated differently simply because of characterization, as in the case of part-time or contract staff in relation to full-time staff. It's common in industries. For instance, in the banking industry, you would see a cashier counting money and dispensing money. You talk privately to him, he tells you, I'm a contract staff. And sometimes this contract staff, they do as much work as full-time staff, if not more. Apart from not being now regulated by the employment protection laws, their salaries may be lower, their salaries may be computed on an hourly basis and things like that. The point I'm trying to make is this. Within the same establishment, because of characterization, you have people who are doing the same work but protected differently. Next, because prevailing labor laws are based on the assumption of traditional employment relationships, they exclude non-traditional work arrangements. Workers in atypical relations thereby become excluded. Some workers become employees for the purpose of some labor, but are independent contractors for purposes of others, such as the case of freelance. I'm sure Madam Sharon will agree that in the profession of journalism, there are many journalists who tell you I'm a freelancer. In other words, based on the content they generate, determines how much they are going to be paid. And they may be doing more than even those who are within the system as full-time. Next, employers rely on the uncertainty of the law to evade labor laws, as we are knowing that most employees will not sue for lack of knowledge or resources or fear of reprisals. The employer simply ignores the law. And lastly, employers evade labor law through the instrumentalities of triangular and quadrangular employment relationships. So added to all of this, the foundational underpinnings or basis of labor law are not left out in the attack. Because labor is not a commodity, you can add today that labor or workers are not robots either. We are taught that work is not just the means by which we obtain the resources needed to put food on the table. It is also a source of personal identity, pride, and dignity. Yet, labor is being commodified in many respects today. We hear assertions like labor is merely different from other commodities. If you take the example of our footballers, and you see now is the transfer season, you hear how you have a right to talk to your agents. They are now bidding. This one is offering 60 million pounds. The other is saying, no, you need to make it 70. The way they are pricing it, how different is that from even the era of slave trade? So, the orthodoxies of the employer being the bearer of power and the worker not being the bearer of power, the employer being strong and the worker being weak, and the employer being contract maker while the worker is a contract taker. All of these assumptions or orthodoxies are also being questioned today. So we are beginning to see phrases like labor law is not a commodity and labor law reduces inequality in bargaining power. They are now being seen as merely making good slogans, or the narrow views that limit our understanding of labor law. Yet, human dignity is involved in the fray. The view that the protection of workers against unfair exploitation becomes a profound rationale of labor law. We employed workers, but what we got were human beings. It's a common refrain in the world of work. And when we look at the logic of collective bargaining and paternalistic legislation intervening in the substance of the employment bargain, we have to see all as a construct of a body of consumer protection for the vulnerable in the labor market, which stands and speaks fairness and decency to the superior bargaining power of capital. In this sense, global labor injustice is acknowledged to be a problem of power imbalance between capital and labor, which cuts across countries in a transnational fashion, at least just as much as it is one between wealthy and poor countries and their respective citizens, of course. In all of this, employers complain that the ideals of labor law not being a commodity, labor law redressing the imbalance of power relations, and the emphasis on human dignity and decency in the workplace all leave little or no room for enterprise sustainability. In the 3 years that I have been a member of the ILO, they say time is up. Where is the chair of the... Anyway, let's see how far we go. So in the 3 years I have been a member of the ILO Committee of Experts, enterprise sustainability has been a recurring decimal in the interactions we have had with the employers group. And now even ILO is beginning to acknowledge. For instance, the standards review mechanism of the tripartite working group of the ILO, which reviews standards now and then, talk about ILO in its review of standards must now aim at ensuring a clear, robust, and up-to-date body of international labor standards that respond to the changing patterns of the world of work for the purpose of the protection of workers and taking into account the needs of sustainable enterprise. I don't know whether you are aware that right now at the International Court of Justice, there is a question ILO had to pose to ICJ, and that is whether within the context of Convention 87, the right to strike is implied. There's been a tussle, varying misunderstanding. If you go to Convention 87, you won't see the right to strike mentioned in the exact articles of the convention. But the Committee of Experts over time had interpreted the convention to say the right to strike is implied in that convention. The employer group says no, it should not be so, because even when we were discussing the right to strike, we deliberately didn't use the word right to strike as part of it because there was no agreement. But the Committee of Experts insists that no, it is part of it. It's because of this back and forth disagreement by the ILO Constitution. Once there is a disagreement as to the application of any standards, if it boils down to one of interpretation, the final say on the issue is the International Court of Justice. So whatever the International Court of Justice says now, for instance, if the International Court of Justice says the right to strike is implicit in Convention 87, It means we at our level, when I say at our level, National Industrial Code, we have always worked on the assumption that it is implicit. It means what we have been doing will be correct. But if the International Court of Justice says it is not, we have to come back and review our stance in the future cases that will come. Because our mandate to apply ratified convention comes with it the mandate of the ILO jurisprudence that go with it. Chairman of the, you said my time is up. Should I go away? So, as true as this may be, the changing landscape of the world of work dictates that we may have to rethink some of our basic assumptions and rationalizations. For we must note that the versatility and mobility of capital and its capacity, please note this, the versatility and mobility of capital and its capacity to seek out labor markets with lower labor standards and costs is one of the long-standing challenges to the effectiveness of social protection function of the labor law, as well as a contributory factor to labor/employment law being at crossroads. The very idea of the factors of production being capital, land, and labor, and which see capital and labor as being in perpetual contest, seems to pale out in the context of the knowledge-based economy of today, where human capital, note the change in terminology, is no longer human resources, it's human capital. Where human capital, labor is now seen and addressed as labor as human capital, is to it what physical capital was to the Industrial Revolution. Remember I told you that the labor law we have evolved from an industrial setting. You have a factory, so you have factory hands coming, they work for 8 hours in shifts. So everything about labor law was centered in that context. Now, today we are talking about knowledge-based economy. It's no longer an issue of you going to set up one huge industry with machinery and so on. You only need a laptop in your house and then maybe 2 or 3 other workers who may be in different countries around the world. And what you bring to the table is said to be your knowledge. So the economy now is said to be a knowledge-based economy. So to this kind of economy, it is human capital that is central to it. Just like capital was to the Industrial Revolution, it is human capital now that is central to this knowledge-based economy. So the logic of economic development and prosperity today requires that full human potential be harnessed and developed. For there is no wealth other than human beings. No wealth other than human beings. The belief is that an economy that ill-treats its human beings has no future. An economy that ill-treats its human beings has no future. I told you of the research in 2012 as to countries that are developed where the rule is you can't terminate without reason, and countries that the rule is you can terminate without reason. The evidence showed that countries with the rule that you cannot terminate without reason were more developed than countries. So, the manner in which human beings are treated can also dictate how developed a country can be. Now, the point is that the essence of labor regulation is to improve the lives of people insofar as work has something to do with it. And work does have a lot to do with it. Human beings are not merely the means of production. Remember I talked about capital, land, and labor, right? As factors of production. But the point today being made is that human beings are not merely the means of production. They are the end of the exercise itself. It is in this sense that labor law is being reconceptualized today. Labor law should not just concern itself with preventing unfairness. in negotiating contracts. It should cover all productive activity and regulate the development of human capital, maximizing human freedom in the process. In this wise, labor law thinking can easily move away from its orthodoxy and cover non-contractual approaches to work relations, such as informal work and other non-traditional labor law subjects, such as unpaid work, education. You will wonder why education. But the point is that it is education that develops the capacity, that skill that you would later be giving out as labor to an employer. So education being the key to all human capabilities. Child care, when we talk about work-life balance, you must also worry about child care. Right now, with the kind of system you see in the West, social deviant attitude and so on, they are all being traced to the manner in which children are now raised. When we were growing up, we never had that problem because children had to undergo a disciplined process. Today, that discipline is lacking, and consequently, you're seeing the effect in the wider society. So where you have a father and a mother both working, and it's a third party who is taking care of a child, it can never be the same. And in all of this, decent work is central. The ILO defines decent work as referable to productive employment, where jobs contribute to the economy and have a positive impact. Decent work also must provide fair incomes. Here, salaries should be sufficient to meet the basic needs and allow for a decent standard of living. Decent work must provide security. In other words, employment should be stable and working conditions should be safe. Decent work also entails social protection. Here, there should be access to health care, unemployment benefits, and other social safety nets, while also offering opportunities for personal development and social integration. In other words, there should be opportunities, if you are at work, for learning, skill development, and participation in society. Decent work also entails freedom of expression and organization. Here, workers must have the ability to voice concerns, join trade unions, and participate in decision-making processes. Decent work must entail equality of opportunity and treatment. Here, there should be fair treatment to all, regardless of gender, race, etc. And decent work must entail social dialogue. Tripartism and bipartisanship, i.e., dialogue between workers, employers, and government should be encouraged. So decent work accordingly emphasizes the importance of not just creating jobs, but ensuring that those jobs are of acceptable quality. The ILO accordingly views decent work as a fundamental part of social progress and has incorporated it into its major strategic policy concepts. Decent work is also a key focus of the Sustainable Development Goal. In fact, it is number 8 in the development goals. And this aims to promote sustainable and inclusive economic growth, full and productive employment, and decent work for all. So, the decent work agenda has thus shifted the focus of ILO from goals to outcomes, with the emphasis being that economic and social policies are development policies serving a common purpose, i.e., improving people's economic and social well-being through economic development. So, instead of just focusing on protecting employees, the scope of labor law should encompass the concerns of those who are dependent on their labor to earn a living. That is, who are not owners of capital, whether they are in employment, are engaged in other forms of working arrangements, or are out of the labor market. Decent work advocacy had made significant progress over the past decade, driven, of course, by ILO decent work agenda. And then I enumerated some of the stages and things that ILO had done in that regard. So, as we hope for the ILO decent work agenda to play a major part in the resolution of crisis besetting employment and labor laws, given that the world of work and the rules that govern it appear fluid, the task ahead for all is how to ensure a future of work that is just. A commentator identified 7 challenges that the future of work faces and which all must grapple with. Globalization and deglobalization. We are now beginning to hear words like glocal. I don't know whether you've heard of it. Glocal is a combination of globalization and localization. And the whole idea is as you go global, think locally. In other words, don't allow the aspects of globalization which are injurious to you. When you hear Donald Trump talk about America first, that's the idea. We cannot, because of globalization, allow ourselves to suffer locally for it. So you are encouraged to go global, but think locally. Then we have climate and ecological transition. We have issues of inequality. We have demography and migration. We have automation and digitalization. We have new forms of work. And of course, new models of business. And then I itemize them and discuss a little bit further. But I'll skip that. Coming back home, the question becomes how we can cope with the new realities in the workplace, such as the gig economy, informality and under-regulated employment relationships, and technological displacements and remote, all of which challenge the old rules. Noticeable gaps and contradictions in our law, such as the outdated definition of worker under the Labor Act, which now may not cover all workers, the lack of protection for gig, casual, or agency workers, the absence of a strong anti-discrimination or data protection provisions at work, an inconsistent application of limitation laws in employment-related litigation, all point to the challenges labor law faces in the Nigerian workplace. The current stopgap is the Third Alteration Act, which inserted sections 254A to F into the 1999 Constitution, and which, to use the words of His Lordship Siraj Ojesi, is a game changer. It has brought a new jurisprudence to our labor relations, which, according to Honourable Justice Ogumiju, cannot be ignored as the law is not static. But is this new jurisprudence making employment/labor law more at crossroads? Commentators like Bayo Adaralegbe think so. In an article he titled, "Wreaking Havoc on the System," he did not spare his pen in denouncing the third alteration to the 1999 Constitution and its evolving jurisprudence, especially as it relates to the employer's right to terminate an employment contract. I had cause to debunk this stance in a 2024 annual lecture I did for the Commercial Law Department of University of Lagos last year. And if you look at a comparison of 2 Supreme Court decisions, Skybank versus Adegu and Dangote versus Aga, again you would show differences. Skybank was decided in relation to quantum of damages for termination of cases. Skybank denounced the common law stance of quantum of damages being payment in lieu of notice. 10 days after, when Dangote was decided, the Supreme Court said no. Without referring to Skybank, the Supreme Court insisted on the common law orthodoxy of payment in lieu of damages as the quantum of damages. Now, I acknowledge that both cases related to causes of action that arose before the 1999 Constitution. No, before the third alteration. And so, strictly speaking, they must be decided based on the applicable laws before that date. But if today those issues arise under the third alteration dispensation, my view is that Skybank is a preferable authority for that purpose. Now, the problem does not even stop there. We have the problem of the limitation law application. And the point I noted here, particularly in relation to the limitations law, you know there are two types. We have the Public Officers Protection Act, which applies to public sector workers, whether state or federal. Then we have the normal limitation law, which ordinarily would apply to the private sector. So in the first instance, I ask a question. Why the distinction between public sectors and private sectors in a manner that allows public sector workers only 3 months to come to court, whereas private sector workers can have up to 5, I think in some instances 6 years? Why that distinction in the first place? Then secondly, even in terms of the application of the Public Officers Protection Act, we've seen an oscillation even by the Supreme Court. And I gave example of 2 decisions of the Supreme Court decided on the same day. One said the Public Officers Protection Act applies. The other said it does not. And of course, I asked the question, even going by apply the most recent rule. That's what they told us, that in the event of conflict, apply the most recent. First, that rule, for me, is an uncritical copying of the rule relating to statutory construction. It is when you are construing statutes that you are advised that the most recent statute is deemed to have repealed the older one in terms of its conflicting provisions. Now, in interpretation of statutes, per incuriam is not a rule. But in the interpretation of court decisions, there is per incuriam rule. And what is the per incuriam rule? It says, where a decision does not refer to an existing authority or law, it is the latter decision that is per incuriam. So if you have 2 judicial decisions, and the latter one did not refer to the older one, going by the rule of precedent, judicial precedent, it is the latter one that is per incuriam. So when the Supreme Court tells us apply the most recent, for me, strictly speaking, Supreme Court has now technically done away with the per incuriam rule. Is this a correct position of the interpretation of the rules? I don't think so. Of course, I can only talk like this if I'm talking to you in an audience like this. If I'm writing a judgment, I will have to apply the most recent rule, the most recent case, because I am enjoined to do that. Court of Appeal had even done that, and I have given example. So, an author wrote, citing some of these decisions of the Supreme Court on limitation law, and said, between a certain period, NIC had done injustice by striking out so many cases on the grounds of the application of limitation law. And I asked the question because the author did not even refer to existing authorities at that time, which also say NIC can strike out cases on grounds that they are statute barred. So, for us as courts of first instance, if you see us oscillate, don't blame us. We are just doing what we are compelled to do. If Supreme Court decides today that Public Officers Protection Act applies to contracts of employment, if I'm doing a case tomorrow, I will apply it. If tomorrow Supreme Court says it no longer applies, next tomorrow I will apply that of tomorrow. And that has been our story. Unfortunately, the lawyers don't like it. Unfortunately, the lawyers criticize us. But I have to explain here that we are simply caught in the web. And the sad part is that majority of the Supreme Court decisions, including the ones that were made in 2025, do not even refer to earlier decisions of the Supreme Court that have said that limitation law does not apply. I can say, because of that, I'm not going to do it. But it's going to go back to the same people for review. And I'm going to be described as a rascally judge who thinks he knows it all. And only God knows what adverbs and adjectives will be used to describe me. Justice Afen calls it theory deficit. And that is a bane of our jurisprudence. You hardly have thought processes. I was discussing privately with a Supreme Court justice, and he lamented. Do you know how many judgments we write? In all honesty, do you think it is humanly possible to think through some of these cases? Back home here in Ghana, the Supreme Court sits once a week. And years back, we asked the Chief Justice of Ghana, why? He said, a Supreme Court justice must have time to think. SN Folabi sent me a case, a UK case. I'm sure you remember the question whether Uber drivers had workers. The UK Supreme Court took arguments in that case in July of the year in question. They did not deliver judgment until February the following year. How many months is that? About 7 months. In Nigeria, our Supreme Court has 90 days to do judgment. And you are expecting a miracle. You see, I sometimes have problems with our thought process. I have never heard lawyers complain. You know the case, sorry for this digression, but I need to make this point. You know the case that returned the former Senate president to Senate? Everybody complains about that case, but nobody sees something more fundamental. The High Court gave judgment against him. 3 Court of Appeal justices gave judgment against him. At the Supreme Court, it was a split decision of 3-2. So if you add the 2 dissenters to 3 Court of Appeal justices and 1 High Court judge, how many do you have? Yet your constitution says it's a decision of 3 justices, that is the law. And you are not complaining. And you think it's normal, we're happy. And I asked the question, assuming the 3 Court of Appeal justices have been earmarked for elevation to the Supreme Court, will you be happy that such an outcome? I remembered when Folabi Kuti decided to take up his first write-up on the third alteration. Actually, that's what brought us together. He had criticized the third alteration. And I was asked at the MBA conference in Owerri to do a paper on finality of NIC decisions. Everybody was clamoring. NIC wants to be Supreme Court of Labor Law. Everybody complained. Ultimately, Skybank and Iwu, based on what I called a wrong interpretation of the Constitution, allowed for appeals to go. No problem, but I've always asked a question. What assurance have you that an appellate process produces just outcomes? What assurance have you that an appellate process will produce a just outcome? You allow thousands of cases to get to the Supreme Court, and you give them 3 months, 90 days to write judgments. Then during electioneering periods, they keep aside every other case, and they do only political cases, and you're expecting magic. And you are expecting magic. It was Professor Gambari who told his students, the view of the road depends on whether you are a driver or a passenger. Justice Oji is here. A while ago, I was asking her about her cases. She lamented that all of a sudden she had over 100 cases due for adoption of addresses. If she allows the adoption, can she deliver 100 judgments in 3 months? She is here. And an SAN complained to me that, cases in NIC are now lying, due for adoption, but the judges are not allowing us to adopt. I said, how can they allow you when they have only 3 months to write judgment? And if they don't, that's a constitutional breach. NJC will come breathing heavily on them. I said, how? It will be foolhardy for her to sit down and say, because it is due for adoption, come and adopt. When in all honesty, she cannot write 100 judgments in 3 months. That's what we are saddled with. Tomorrow we complain about the justice system. Yet we forget. It was Justice Afen who said, the very fact that the Constitution says you have a right of appeal, it means the Constitution does not even trust the lower courts. The fact that you have a right of appeal, when I say right of appeal, appeals as of right, it means whatever you do, the Constitution does not even believe you've done anything. That's why politicians will tell you, we got judgments, but not justice. That's why a politician, a court of first instance and a court of appeal will do a decision. They will say, until the Supreme Court talks, we are not obeying. So why didn't the Constitution simply say, go to Supreme Court and get whatever verdict and live with it? Until lawyers begin to advise clients to come to terms with decisions, whether good or bad, we are going to have issues. So long as you believe the appellate process must see itself through, elsewhere you go to some jurisdictions, there is a decision a high court judge will give. All the parties will know there is no point going to appeals. Not in Nigeria. Not in Nigeria. So, there are basic structural problems, some constitutional. I have always asked the question whether in the protection of labor rights, it is even good to constitutionalize them. I have asked that question in some of my previous write-ups. Until we understand that there are basic structural problems, not just with the system, but with even the laws that give rise to the system, we are going to have issues. So, that's the problem with relation to limitation law. The other point I made is the question of enforcement. And I'm very particular about CBN. You know, for public sector employers, you can't, particularly for monetary claims, you can't go after CBN in garnish orders according to Section 84 or so of the Sheriff and Civil Process Act until you get the Attorney General's consent. I did a case, and it was CBN. The judgment debtor didn't even oppose it. We had issued a decree nisi against CBN. It was CBN that was coming to object. I had to ask the lawyer of CBN in open court, is this money your own? The man who is the judgment debtor is not even saying no. You are the one who is saying no and going up to Supreme Court. There's one they did, and they raised this funny argument that because it is a garnishee proceedings, they have a right up to Supreme Court because that is not the kind of action from NIC that the Constitution restricted to only the Court of Appeal as a final arbiter, appellate arbiter. And the Supreme Court said, no, an action is an action. But you can see how a lawyer would carry a case to the Supreme Court and the strain or strange arguments being raised to justify going to Supreme Court. I sat in my office. A 2023 decision of the Court of Appeal was sent to me. The Court of Appeal directed that I should reassign the case for rehearing. It was a garnishee proceedings. Central Bank had complained that, I think it was Justice Hastrop, so I can't remember, who did the initial case and gave a garnishee order against CBN. CBN now objected that consent of Attorney General was not secured. Now, of course, I have reassigned the case. But please, when you go back home as a lawyer, read Section 84 of the Civic and Civil Process Act again. On a literal interpretation, it talks about where money liable to the attached by garnishee proceedings is in the custody or under the control of a public officer in his official capacity. First, Civic and Civil Process Act did not define who a public officer is. But the Interpretation Act does. And it defines it in relation to a human being, not an artificial person. Second, this provision talks about his official capacity. The Interpretation Act again says anywhere in an act the masculine is used, it includes the feminine, right? It did not say it includes the neuter. We are told there are 3 genders, is it not? Masculine, feminine, and... No, they call it neuter. Not neutral, neuter. That's what they call it, at least. That's what we were taught when we were in primary school. 3 genders. The Interpretation Act talks only about masculine and feminine. That's the language of Section 84. And then you come around and say, CBN is a public officer for this purpose, for God's sake. Then it goes on to talk about appropriate officer in relation to money which is in the custody of a public officer who holds a public office. How can CBN hold a public office? And I can bet you, if it was the governor of CBN that was now cited, he will claim that he is not CBN for this purpose. And yet, and this is despite even the clarification by the Supreme Court, we still have Court of Appeal decisions saying you require an Attorney General's consent. In fact, there are Court of Appeal decisions that have said this provision is not unconstitutional relative to Section 287. Section 287 says how judgments are to be enforced of the Constitution. All courts and persons are subject to enforcement of any judgment of the Supreme Court, below the Supreme Court. For Court of Appeal, then for us, Court of First Instance, it is the lower courts. And that is why you cannot carry judgment of NIC to Federal High Court for enforcement, because there is no constitutional mandate for Federal High Court to enforce the judgment of a court of coordinate jurisdiction. It can only apply it as a persuasive authority. Yet there are decisions that say this Section 84 of the sheriff and civil procedure, which requires Attorney General consent, is not unconstitutional. The Constitution says you can go ahead and enforce against any person or authority. It's an Attorney General, not a person or authority. So why would you want his consent before? In any event, which Attorney General will ever give you consent anyway? But we are the architects. And that's why I think Afe Babalola wrote in his book, it's not getting the judgment that is the issue. It is getting the fruits of the judgment. I crave your indulgence to read the concluding part. To conclude this keynote address, it is self-evident that certain policy and legal reform imperatives are necessary. For instance, our notion of employee must be expanded to include, for instance, gig and platform workers. The notion of employer must equally be expanded, though I acknowledge that we have used Section 91 of the Labor Act to give the needed expansive meaning. The notion of employment relationship needs specific attention as well. We need to agree on the extent of flexibility needed in our workplaces, such that the Labor Act should contain provisions which combine protection with productivity. Enforcement of social protection schemes such as pension, insurance, and maternity deserve equal attention. And I ask whether this would be heretic. There is need to formalize the jurisdiction of the NICN over the informal sector as well as over contracts for service. In fact, I did that using the Supreme Court decision of Shino Security Limited and Afropac. In that case, the Supreme Court decided that a contract between two companies for the supply of labor, security guards, is a contract of service, not for service. I'm not sure most lawyers note that because I see arguments in briefs that never factored this. So I was able to use that case in taking up jurisdiction in respect of the interpretation of a facility management agreement between two corporate parties. And then if you look at the Constitution in donating jurisdiction to NIC, it uses labor, employment, and then qualifies it with the word any labor, any employment. Now, when you say any labor, does it suggest that there is a restriction to only contracts of service? I don't think so. In fact, it was a young lawyer who drew my attention in one of his briefs when we were taking the facility management agreement issue, who said, no, go back to the Constitution and take a second look. The Constitution shouldn't have used labor and employment if it meant it to be the same. But in emphasizing, you must also realize that labor encompasses not just contracts of service, but also contracts for service. And more importantly, when the ILO makes standards, they don't make standards for contracts of service alone. They make standards for the workplace. And the workplace is a place where all who work are covered. You don't have to work as a paid employee. You can also work as an independent contractor. So, Nigerian employment / labor law may be at crossroads, a breaking point, some would say, which call for balancing flexibility and fairness. The point, however, remains, as a commentator, Harry Artos, puts it, if justice is not handed down to workers from on high by benevolent judges or enlightened employers, mobilization remains the only recourse. I repeat, if justice is not handed down to workers from on high by benevolent judges or enlightened employers, mobilization remains their only recourse. And once labor law can no longer advance justice in the labor market, it will lack legitimacy. But, and this is where an additional problem is, which problem also typifies the fact of employment/labor law being at crossroads. The justice which labor law can advance, often called labor justice, is one that even ILO shies away from in defining. I made this point and I tried a reconceptualization in a lecture I delivered in honor of Honourable Justice Paul Galumje, retired Justice of the Supreme Court. What other proof do we need to show that employment/labor law is at crossroads than that, including the ILO, we cannot even agree on what labor justice is? I thank you all.
A round of applause for my Lord as he walks to his seat. As we will always say, my Lord, thank you for that well-considered judgment. From experience, when you are planning an event, the first difficult task you have is trying to have a theme. And the next problem you have is trying to identify a keynote speaker that can speak to that theme. Then you now have to pray that your keynote speaker is available on that day. And when that day comes, he doesn't assign and send you a text of, "I'm so sorry, but somebody will represent me." My Lord, we thank you for not only being here in person, we thank you for agreeing to be here, and we thank you for taking out time to put a 30-page, insightful, and educative document. A round of applause for my Lord. We're indeed very, very grateful. As we proceed, I would just like to quickly recognize my Lord, Honorable Justice Yelwa, who walked in while we were speaking. Thank you, my Lord, for being here with us. Thank you so much. Also to our audience who are online, I'm sure we're all having a great time. I see the numbers are going up and everyone is indeed glued. We'll have on the screen very shortly the QR code for the program. If you don't have that already, please kindly scan. Also, we'll have a QR code in due course as it relates to the NBA ICLE points and would advise on how you can claim those points.